Question number 762. The right of a defendant to access information in a court dossier case issue is the first part of paragraph 2 of Article 33 of the Criminal Procedure Code, which prevents a defendant from gaining timely access to all dossiers and exhibits in the case unconstitutional. Holding. The first part of paragraph 2 of Article 33 of the Criminal Procedure Code, which is stipulating that a per se defendant may pay the required fee in advance to request copies of minutes in the dossier at the trial, yet which fails to provide a defendant with a counsel the right to directly access information in the dossier, or a defendant with or without counsel the right to request copies of anything other than the minutes in the dossier, hinders the defendant from effectively defending the case. In this, the first part of paragraph 2 of Article 33 of the Criminal Procedure Code is in contravention of the constitutional guarantee of due process under Article 16 of the Constitution. The authority concerned shall amend the relevant provision of the Criminal Procedure Code in accordance with this ruling of interpretation within 1 year from the date of issue of this interpretation. Should the amendment not completed in time, court should at the trial follow this ruling by giving all copies of dossiers and exhibits to a defendant who requests them after the necessary cost has been paid in advance. The petition for preliminary injunction is thus dismissed. Reasoning. I will skip the background here. Article 16 of the Constitution provides the people with the right to initiate litigation to ensure the right to a fair trial. According to the due process of the law, the right of a complete defense includes protection of the access to a fair trial. C01 Interpretation 654 has in criminal trials, a defendant is generally entitled to timely access to all necessary information related to any accusation against them in the dossier. The stipulation at issue clearly provides that a per se defendant may pay the necessary fees in advance to request copies of the minutes in the dossier at trial. It seems that only a per se defendant may directly access information in the dossier by requesting copies of the minutes. This excludes a defendant with counsel from making such a request, thereby limiting the scope of access to information in the dossier to the acquisition of copies of the minutes, rather than any other necessary information in the dossier. This excludes a defendant with counsel from making such a request, thereby limiting the scope of access to information in the dossier to the acquisition of copies of minutes rather than any other necessary information in the dossier, and only allowing the defendant to pay fees in advance to request copies of dossiers. This does not allow a defendant to obtain information in the dossier by perusing it and then either copying or photographing it or by any other means. Whether the subject scope and method of the stipulation at issue comply with the requirements of due process of law must be evaluated by a comprehensive judgment and the affirmation of factors such as the requirement for a full defense by the accused, the content touched upon in the case, and the security of a dossier, whether or not there is an alternative process and the efficient use of judicial resource. First, regarding the subject's right to access as the constitutional right to initiate litigation, ensures the right to full defense. A defendant with or without counsel should be entitled to directly access information in the dossier in person, since the defendant personally experienced the relevant facts and may be in a better position than counsel to decide which information in the dossier might defend the case effectively. Permitting only counsel to examine the dossier is not a complete substitute for the right to access to the defendant. The stipulation at issue, providing that a defendant with counsel might defend the case through examination of the dossier by the counsel, is in violation of the above-mentioned due process of law under the Constitution, because the defendant with counsel will not be entitled to directly access information in the dossier. Okay, I'll read it again here. The stipulation at issue providing that a defendant with counsel might defend the case through examination of the dossier by the counsel is in violation of the above-mentioned due process of law under the Constitution, because the defendant with counsel will not be entitled to directly access information in the dossier. Second, concerning the scope of the right to access all information in the dossier is important for the court to proceed to a trial based on the constitutional concept of due process of law. A defendant is entitled to access to all information in the dossier to effectively defend the case. The stipulation at issue based on the reasoning that the records and the documents other than the minutes in the dossier which may be used as evidence shall be investigated according to the law by the judge at the trial, so that a per se defendant might have access to the information therein. It is in violation of the above-mentioned due process of law under the Constitution, because the defendant would be entitled neither to timely access to all documents and exhibits other than the minutes, nor to comments on all related information other than the minutes in the dossier during the court investigation, which impedes an effective defense by the defendant. Last, in regard to the method of exercising the right to access, the stipulation at the issue, which is based on the view that because the defendant himself would closely be interested in the outcome of trial, directly allowing the defendant to access all information in the dossier might increase not only the cost of protection of the dossier, but also the manpower required for safeguarding the defendant on the way to the court to examine the dossier should the defendant be in custody. Thus, the first part of paragraph 2 of the article is newly adopted to protect the right to defense of a per se defendant as well as to ensure an effective utilization of a judicial resource, was reasonable at that time in 2007 in not allowing the defendant to examine the dossier in person. However, given that the technique of copying and the equipment to do so are now much more common, copies referred to in the stipulation at the issue should go beyond the minutes and include duplicates, such as photos of exhibits, copies of electronic records, and e-files, since copies play almost the same role as the original do at the trial. The stipulation at the issue providing that access to information in the dossier by paying for copies, which might reasonably be extended by to duplicates in advance, constitutes no violation of due process, as it does not impede a defendant from effectively defending the case. Should it happen that the defendant be in a situation such that the failure to examine the dossier leads to inadequacy in upholding the right to effective defense, it is certain that to protect the defendant's right to litigation under the Constitution, the defendant might at any time examine the dossier in a timely fashion, either with the presiding judge present or with the designated judge approval, on the premises that the security of the dossier be ensured. To sum up, except for restriction under the proviso of paragraph 2 of Article 33 of the Criminal Procedure Code, the stipulation at the issue which deprives a defendant of the right to directly access to information or to request documents other than minutes in the dossier impedes a defendant from effectively defending the case. The above-mentioned paragraph 2 of Article 33 of the Criminal Procedure Code is inconsistent with the meaning and the purpose of Article 16 of the Constitution, which protects the right to litigation. The authority concerned shall amend the relevant provision of the Criminal Procedure Code in accordance with the ruling of this interpretation within 1 year from the date of issuance of this interpretation. The court should follow this ruling to give all copies of a dossier and exhibit to a defendant, whether per se or not, who requests them after a necessary costs have been paid in advance at the trial, should the amendment not be completed in time. The other claims also filed by petitioner 2, that Article 27, paragraph 1 and 2, Article 29, 30, 31, paragraph 1, subparagraph 4, and Article 95, paragraph 1, subparagraph 3 of the Criminal Procedure Code, and Article 911 of the Attorney Regulation Act, Item 1 and 2 of the Notice of Request for Reviewing the Criminal Dossier, and Article 5 of the Constitutional Court Procedure Act, Article 5, Paragraph 3, subparagraph 2 of the Legal Aid Acts are unconstitutional, should be dismissed because those articles were not cited by final ruling. The claim that the paragraph 1 of the Article 33 of the Criminal Procedure Code is unconstitutional, as well as the petition filed by Jiang Mannan, the assistant of the petitioner 2, claiming that the above-mentioned article provides to the assistant of petitioner 2 no right to access to information in the dossier should also be dismissed according to the paragraph 3 of Article 5 of Constitutional Procedure 8 for not satisfying the requirements set out in paragraph 1, subparagraph 2 of the same article, because the petitioner did not submit a specific reason for the information of objective belief that the law is unconstitutional. Moreover, it is no longer necessary to rule on the petition for preliminary injunction filed by petitioner 2, as the case has been completely interpreted, and given that the petition in the same case filed by Mannan Jiang is dismissed, it is no longer necessary to review the related petition for preliminary injunction. It should also be dismissed.